Hello. There's a question I get asked quite often if someone needs to file bankruptcy and they file bankruptcy. Will I have to go to court? Will I be in front of a judge? Will the judge yell at me and be mad at me because I filed bankruptcy? What will happen? And I want to ease your mind right now about that process because it's a lot easier from that perspective than most people think. My name is Alan Murphy with Gillespie Murphy, and I want to tell you at least 3 things to understand about the meeting with the trustee, which is called the meeting of creditors or a 341 meeting. Number 1, it says meeting of creditors, but rarely does a creditor show up at that meeting because they can get everything online with the technology we have this day and time. They don't need to go to the meeting to ask questions. They can get it from the bankruptcy court when a bankruptcy petition is filed. So you don't have to worry about somebody showing up and berating you because you're filing bankruptcy and owe them money. Just take that out of your mind. That rarely happens. Maybe happens in 1 or 2% of cases, but it rarely happens. Number 2, you should never, ever have to see a judge if your bankruptcy case is done properly and proceeds through the system the way it should. The way cases are done now, you'll see a bankruptcy trustee, that's a lawyer assigned by the court to review your paperwork, to make sure it's accurate, and to administer your case from the filing to the completion. If all goes well, you should never see a judge. And that's the goal. It's not that judges are bad or they're going to be mean to you. It just makes it smoother and easier for you. And if your attorney knows what they're doing, and I've been doing this for 30 some years, you should never see a judge once your case is filed, as long as everything goes like it should. And it should if it's done properly. Number 3, people are worried about how long the meeting is going to take and what's going to happen at the meeting. I want to ease your mind about that as well. Right now, because of COVID, meetings are done by Zoom. Some may be done in person, but Zoom right now is the way to go. They may be done in person in the future. But regardless of whether it's a Zoom meeting or an in-person meeting, it should take no more than 5 to 15 minutes. Yes, 5 to 15 minutes. The trustee is going to ask you some general questions. Who you are, where do you live, are you married? Do you work at the same place? Do you own this house? Do you have this car? And primarily he's going to say, did you list accurately the information in your petitions about what you own and who you owe, and basic questions such as that. His goal is just to make sure that things are accurate. If he has something specific, he'll ask you, but normally very simple routine questions. If questions come up after the meeting, he'll advise that your attorney, or he'll advise you if you're representing yourself, what he needs, any information he might need in addition. But the meeting itself is very non-confrontational. It's not adversarial. The trustees are nice. He's going to give you some information at the beginning of the meeting. He's going to bring you up to a table. He's going to put you under oath. He's going to answer some simple questions, probably maybe 10 to 15 questions. The meeting should not take more than 5 to 15 minutes in most cases. The only time it might be longer if someone has a complicated business situation, but that is rare too. And most of the time those are answered in fairly short order, and the trustee just may ask some additional information later. So don't worry about that. Going to court should be the least of your worries. You just want to make sure your petition is filed accurately, correctly, so when you meet with that trustee, you can leave with a smile on your face knowing everything is okay, my bankruptcy is okay, I've done well, it's going to be good, life's going to be better. I hope this has answered those questions and eased any concerns about court in bankruptcy, especially the 341 meeting with creditors. It's really pretty easy, it's pretty laid back, it's serious, but it's not adversarial unless you make it adversarial by not answering the questions that the trustee is asking. Thank you very much. Hope this has helped. If you have any other questions, let me know. Alan Murphy with Gillespie Murphy. Want to help you any way we can with any debt situations or other questions you might have about bankruptcy or finances. Thank you very much. Have a great day.